A court speaks, a people has won. The judgment is called historic. For a brief moment, the law appears to have crossed a boundary that once seemed immovable. Yet, the final gavel rarely marks the beginning of justice. More often, it moves the struggle into a quieter place. The offices, procedures, files, budgets, and calendars of the state bureaucracy. This is the paradox of the unenforced victory. Indigenous peoples may succeed before an apex court for a human rights tribunal, while the material conditions condemned by the court remains in place. The turbines continue to turn, explosives remain buried, evictions continue. Other indigenous nations are told to begin the same long litigation again. The gap between judgment and consequence is usually described as a compliance problem. But the deeper question is not only why the states fail to act, it is what happens to the meaning of the judgment as it passes from the court into administration. The central claim is that administrative inaction is often a semiotic translation failure. The state receives a judgment, but not the legal word from which the indigenous claim arose. Indigenous legal orders are commonly relational and place-based. Law may live in land, water, kinship, memory, ceremony, movement, and duties among human and more than human beings. The modern state works through another grammar: statutes, permits, maps, zones, ownership categories, deadlines, and quantified compensation. When a court recognizes an indigenous right, it attempts a difficult translation between these legal sign systems. The judgment introduces a foreign meaning into the administrative body of the state. The bureaucracy then reacts as an immune system reacts to unfamiliar matter. It does not always reject the judgment openly. It may acknowledge the words while isolating their effects. The court has translated the claim once. Administration translates it again. At each passage, parts of its meaning may be filtered out. What survives can be reduced to a manageable case, a technical problem, or a payment. The legal sign remains visible, while its capacity to change the world is arrested. 5 theoretical threads. 5 thinkers help explain this process. Patrick Glenn treats the Chthonic legal tradition as a living legal tradition, not as a primitive stage awaiting state recognition. Its law is carried through relationships, ecological knowledge, oral transmission, and continued practice. Matthias Oren shows how the international legal order remains structured by Westphalian sovereignty. The claim that the state holds exclusive authority over territory. Indigenous peoples whose legal orders precede and cross state boundaries appear within that system as a structural challenge. Robert Williams traces the vocabulary of conquest through Western legal thought, the language of civilization, improvement, productivity, and universal progress has repeatedly converted indigenous presence into an obstacle to supposedly higher purposes. Yuri Lotman's semiosphere helps us see the boundary between sign systems. Translation occurs at the boundary, but so do distortion and exclusion. And Roberta Kevelson, drawing on Peirce understands law as an open process to semiosis. A judgment is not a dead sentence on a page. It is a sign meant to grow through later interpretations and practical acts. When bureaucracy prevents that growth, semiosis is arrested. 2 legal grammars. The conflict is therefore deeper than disagreement over policy. In one legal grammar, land is an animate legal subject, a field of relations, obligations, histories, and authority. In the state grammar, law is usually an object divided by boundaries, registered by title, and allocated through administrative power. Relational sovereignty may be layered and shared. State sovereignty presents itself as exclusive, territorial, and final. A court can partially bridge this divide. It can declare that a license is invalid, that Aboriginal title exists, that consent was absent, or that an eviction violated protected rights. But the court still speaks through the language of the state. Its translation is incomplete. The judgment then enters an administrative system trained to preserve continuity. What appears to the community as a demand for restored relations may appear to the bureaucracy as a file requiring closure. What calls for transformation becomes implementation. What concerns authority becomes consultation. What concerns land becomes compensation. 4 mechanisms of disobedience. The semiotic immune response operates through 4 recurring mechanisms. First, hyper-narrow literalism. The judgment is confined to its parties, facts, territory, and formal order. Its wider principle is prevented from spreading through the legal system. Second, temporal drag. Reviews, negotiations, assessment, and new procedures multiply. Time passes, but the material violation remains. Administrative language expands as practical remedy recedes. Third, the reassertion of the smooth system. The indigenous claim is converted into categories the state already knows how to process: money, mapped parcels, technical mitigation, project management, or a new consultative forum. The state appears to respond while preserving its underlying territorial logic. Fourth, discursive reconquest. The old language of conquest returns in modern clothing. Indigenous rights are placed against a universal good: economic development, green transition, conservation, national interests, or social progress. The indigenous people is again presented as a particular interest that must yield to a larger public purpose. These mechanisms rarely act alone. They reinforce one another. This is not simply bureaucratic incompetence. It is bureaucratic competence directed towards containing the judgment rather than carrying it forward. 4 cartographies of friction. The pattern appears across 4 continents. In the Norwegian Fosen case, the Supreme Court held in October 2021 that wind power licenses violated the cultural rights of the South Sami reindeer herders. Yet, the turbines continued to operate for more than 500 days while ministries reviewed, mediated, assessed, and delayed. The eventual settlement provided compensations and a new pasture arrangement. The turbines remained. The language of green transition placed a universal climate purpose against Sami rights, repeating an older colonial structure in a new vocabulary. In Sarayaku against Ecuador, the Inter-American Court held that oil exploration had entered Kivika territory without free, prior and informed consent. Around 1,400 kilograms of explosives had been placed in the territory. More than a decade after the judgment, significant quantities remained. Removal became a sequence of technical plans, budgets, and postponed procedures. To the state, the explosives became an environmental remediation task. To Sarayaku, they marked a continuing violation of territory as a living legal subject. In Silcock Nation against British Columbia, the Supreme Court of Canada issued the country's first declaration of Aboriginal title over a defined territory. The judgment could have transformed Crown land administration. Instead, it was largely contained within the Silcock case. Other First Nations were still required to prove their title through costly, prolonged litigation. The precedent was recognized, but its growth was confined. In the Ogiek case, the African court found that Kenya had violated the rights of the Ogiek people in the Mau forest. Yet conservation continued to serve as a language for displacement. A universal environmental purpose was used to justify removing the people whose law and life were bound to the forest. Again, the state changed the justificatory frame while preserving the colonial relation. Beyond judicial utterance. Across these cases, the same narrow repertoire returns. Different courts, governments, political pressure, and legal systems produce remarkable similar forms of administrative resistance. The compliance gap is therefore not only the absence of enforcement, it is evidence of what the state's administrative grammar is designed to refuse. More favorable judgments will remain essential. Stronger monitoring and political pressure also matter, but neither can complete the work alone. Unless administration itself changes, each new judgment will encounter the same filters at the boundary between judicial recognition and exclusive action. The task is not merely to add indigenous concept to existing procedures. The state must become capable of receiving indigenous legal signs without immediately converting them into its own familiar categories. It must recognize land as legally relational, sovereignty as potentially shared, and continuing relationship as a legal practice rather than an administrative inconvenience. The living relationship. An alternative legal semiotics already exists in indigenous treaty traditions. The two-row wampum offers a lasting image. Two vessels travel on the same river. Each follows its own path. Neither attempts to steer the other. The relationship is not settled once and for all by a signature. It must be renewed. The convent chain must be polished. The council fire must be kept alive. Law grows through repeated meeting, interpretation, and practice. This is the opposite of arrested semiosis. It treats law not as a closed text whose work ends when a court speaks, but a living relationship whose meaning must continue into the world. The court remains an essential venue, but it can't be the place where the work is finished.